do our usual Zoom housekeeping and instructions. Quick disclaimer, this Zoom session is general legal information, not legal advice. And the chat function is intended for questions or requests for clarification. And commentary in the chat is also not legal advice. And we would probably have time for additional questions today, so please put them in the chat. Okay, let me let one more person in. Okay, I think we could start with the first question today. The first question is, can a forgotten line item be added to the budget before ratification, but after mailing the draft to the owners? We forgot to add an income line item for our $1.50 paper billing charge. This fee is billed on our bi-monthly cycle. The short answer is no. And that's if you follow the budget ratification statute strictly. But you can still collect income and spend on expenses that are not reflected in the budget. And that's because a budget is a financial plan. The actual expenditures and receipts will be different, but as long as there's no change in the monthly or annual assessment, the board can adjust their projections for income and expenses at any time. And that statute is RCW 6490-525. And that statute specifically says within 30 days after adoption of any proposed budget, the board must provide a copy of the budget to all unit owners and set a date for a meeting of the unit owners to consider ratification. So again, the short answer is no. The budget and the assessments tied to it that the owners are voting on at the ratification meeting should have no change between the board adoption and the ratification meeting. And if the amount is nominal or would result in a surplus of funds rather than a deficit, it may be a low risk for the association to include in the financials after the budget is adopted. Ken, would you like to add anything?
Yeah, I'm actually reminded of something else because it sounds like this is a client which is billing owners for the owners paying their assessments. To that, or they're billing owners for sending a paper bill to the owners to pay their assessments. And there was a change in the statute last year, which essentially says that there has to be some way for owners to pay their assessments with no fee to the owner. So I'll say a growing trend has been having some kind of a surcharge or convenience fee or processing fee on websites, or equivalent to kind of what credit cards charge. And so the legislature passed a law basically saying there has to be some way for the owners to pay their dues without incurring any additional fees. So not directly related to the question, but it did make me think of it. Second question is there a standard that states a specific noise abatement specification for flooring in condominiums? So the short answer is that yes, there are two standards. One is the minimum set by the building code. And in the Seattle Building Code, that's section 1206, which requires the flooring assembly for all multifamily housing, so condos and apartments, to test at least 45 IIC, which is impact sound, and 45 STC, which is airborne sound, between units, and it has to test at 50 for both of those measures between public areas like hallways and the units. So that's the standard one. The second standard is that the Department of Housing and Urban Development has put out a set of recommended standards for how much sound should be reduced between dwellings And they have three categories of housing, which include luxury housing and kind of basic housing. And that set of standards has been around for, I think, 4 decades or so. And it sets much higher standards for what they believe should be the sound reduction between units, where it's more in the range of 60. So these numbers are approximately equivalent to how many decibels of sound there is reduction from one side to the other. So if in theory the sound was 80 decibels on one side and the floor is performing at a rate of 50, it should only be 30 decibels in the listening unit. But the two standards then get adopted differently by different associations. You don't have to adopt a standard to require, at a minimum, the building code standard. And one of the things that I worry about a lot is that many associations that have carpeted floors um, don't understand that the carpeted floor is going to test somewhere in the range of 65. It is very quiet compared to the wooden floors. And so changing from a flooring assembly which tests at 65 to one that tests at 45 is a really significant change. A change of 10 points is approximately the equivalent of doubling or reducing by half the perceived level of sound. And so these are the two standards which exist, and associations often want to adopt some kind of objective, measurable standard, and those are standards you can pick. These can be measured by an acoustical engineer coming in. To measure for impact sound, they put a little tapping device on the floor and it hammers on the floor at a very specific volume. And then they measure downstairs what the sound level is. And there's a lot of very detailed specifics about how close to the wall you're supposed to be when you measure the sound, and uh, what the characteristics of the room are like, meaning if it's empty or if it's full of furniture, those will make differences in the measurement. But you can adopt standards, and you can put them into your condominium declaration, or you can adopt them in a policy if your declaration allows you to do that. So anything you want to add, Diana?
Nope, I think you covered it. The next question we've been getting quite often, and it is, do you need to give notice to all owners of a meeting between the board and an attorney? And the short answer is yes. You must provide at least 14 days notice or qualify for exceptions to the 14 days notice to all owners for all board meetings. And when you meet with your attorney, you would enter executive session at a board meeting to discuss with your attorney. And this is provided for in RCW 6490-445, Section 2A, which lists the 5 topics the board can discuss during an executive session. And the 5 exceptions are: 1, to consult with the association's attorney concerning legal matters. You could also discuss existing or potential litigation or mediation or administrative proceedings in executive session. You can discuss labor or personnel matters, discuss contracts, leases, other commercial transactions that are currently being negotiated. And lastly, you can discuss matters that would violate the privacy of a person in executive session. And again, the most important thing is that these executive sessions are still happening at an open meeting. You would call the meeting to order and then provide an owner comment period, which is required at the start of every board meeting. And then the board would adjourn to executive session to talk with the association's attorney and to take any board action that you would return back to the regular open meeting, because all board decisions should happen back in the regular board meeting. And as for notice, generally you should be giving at least 14 days notice to all owners. You can give 7 days notice for circumstances that you could not have reasonably foreseen, and shorter notice may be allowed in emergencies, but emergency is so narrowly defined in RCW 6490-502 that most times you would want to talk with your attorney to see whether you qualify for one of these emergency exceptions. And lastly, you are still required to provide notice even if there isn't an emergency. Ken, is there anything you would like to add to that?
Well, the answer you wrote said technically, yes, you have to have a open meeting before you can consult with an attorney. As a practical matter, we know that conversations between attorneys and boards, or attorneys and managers, or attorneys and individual board members are taking place outside of regular meetings because they are necessary to respond in a timely manner to demands or conditions which are being put upon the association. So there is a sort of what I think of as a savings clause in the meeting statute, which is 445 subsection 2L. And it's near the end of all those requirements which Diana was just talking about. And it says that an action taken by the board is valid even if all the procedures of the statute were not followed, unless it has been challenged and overturned by a court. And I don't know why the legislature put such onerous and strict provisions on the requirements of the board to meet and deliberate and try and conduct the business of the association. But then they did put in this provision, which basically sort of says, well, we don't care about all of that. If you've made a decision and the owners know about it, they've got 90 days and within which to challenge it. So you're going to balance strict compliance with the statute against what you need in order to conduct the business of your association. And if you've got a circumstance, which of course our office sees frequently, where an owner has demanded something be done within a fairly short period of time, like a week or 10 days, and you can't have 14 days notice to call a meeting in order to have the board deliberate and consult with an attorney, then you're going to violate part of the statute in order to get a response and get advice from an attorney. And I think that the risk is pretty low that you will have someone challenge what you've done if the actions you're taking are in the best interest of the association. So there's a lot of things in life where there may be strict rules and laws, and you basically work around them, or you cheat the system a little bit because you need to. It's kind of like the speed limit on the highway may say 60 miles an hour, but there's nothing to actually stop your car from going faster than 60 miles an hour. So try and exercise reasonable judgment and act in good faith, and you should be okay. Anything you want to add, Diana?
No, that's a good point. I could move on to the next question. Next question is, can an ACC request be approved with an email vote? And the short answer is no. Approval of ACC requests is probably not ministerial action. And as you know, the meeting statute says that board actions other than ministerial actions must be done in an open board meeting with at least 14 days notice to all owners. And ministerial actions are not defined in the statute. But even if this was to be a ministerial action, it would still require unanimous consent of the full board for the board to make decisions outside of a board meeting. And as Ken just stated, you have what we call the savings clause, which is RCW 6490-445, Section L. And that provision is where procedures required by the association are still considered valid unless it's set aside by the court. So the board would have to decide if the risk associated with voting by email without a meeting and notice to owners of that meeting is acceptable in order to accomplish other goals, like providing a timely response. And that risk will vary with different issues and with whether or not owners or board members are objecting. And again, as Ken said, try and exercise reasonable judgment. Would you like to add anything to that, Ken?
Well, I'll touch on whether or not you could make it a ministerial action. I think if you had, in this example, a policy which stated specifics about what kind of ACC requests could be approved. So let's say if it was specific to a heat pump and you had a policy that said where the heat pump could be located, how loud the heat pump could be, the kinds of contractors required to install the heat pump. If you had a specific set of criteria and the application met that criteria, then it might qualify as a ministerial act which the board could approve via email. If it was something unusual, I don't think you could create a policy that would provide for it. But certain kinds of requests that if you get on a routine basis, things like heat pumps or installing screen doors, maybe those things you may be able to get to a standard. If it's for replacing of roofing material and you have a specific set of roofing products which are approved under your policy, then that would be a way to turn this into a ministerial act. And that's one way of trying to work around the onerous meeting requirements is to standardize more things and put them into policies so that you can approve them by email. Next question. Does our association have to use accrual accounting? So we're going to answer this based on WUCIOA because everyone's going to be using WUCIOA soon. There's a slightly different answer for the Condominium Act, but the short answer to the question is both yes and no. The statute, which is 6490-530 sub 1, says that you must prepare at least annually a financial statement in accordance with accrual accounting practices. So at least once a year, you need to use accrual accounting to produce a financial statement. It does not say you have to use accrual accounting the rest of the year. So you could use cash accounting, which records income received only when it's received and expenses only when they are actually paid. You can use that on a more regular basis, but make sure that you produce at least once a year a financial report that's based on accrual accounting. Most CPAs are going to probably use accrual accounting in their audit, and it may be that would qualify as the at least annually requirement in the statute. So accrual accounting is in theory, a more accurate picture of the financial condition of the association because it reflects money owed to the association which has not yet been received, and it reflects expenses the association is committed to, even if they have not been paid yet. So do you have anything you want to add, Diana?
No, I do not.
All right, I've got number 6 then. Can boards make allowances for new building materials even if their CC&Rs specify something specific? Would an amendment be needed? So the short answer, of course, is it depends, or maybe, because it will depend on the kind of material that's involved. So we have a lot of clients where there's a specification that the roofing must be cedar shingles. These are generally fairly old, like 40 and 50-year-old communities. And the developer was very concerned about the exterior appearance. But we have a lot of concern now about fire related to cedar shingles. And so one thing to look at is whether or not a statute has been created that overrides the provision in your declaration. And for things related to fire or related to drought, there are statutes which have been implemented which would override your condition. So the legislature adopted a provision about what they call fire hardened materials. And so if the owners wanted to avoid cedar shakes and use a material which is less prone to fire, then the statute would give the owners the right to do that. The association could still regulate the kinds of fire hardened materials, which would mean you could rewrite your document or your policies without an amendment to the CC&Rs to allow the use of metal or asphalt shingles. Okay. You could probably apply the same thing for siding if you were going to use cement fiberboard siding instead of wood siding. Okay. So those are situations where you would not need an amendment in order to allow different materials. If you were if you had something which was specific and not related to the special conditions which the legislature has looked at, then our recommendation would be to go ahead and amend the declaration so that you were not violating it if you allowed different materials. Trying to see if there's something else. We also get back to a section which I've talked about, I know, in several previous meetings, which is the statute about the board's ability to decide how to enforce the CC&Rs. So section 6490, 405, subsections 7, 8, and 9 talk about the board's discretion to not enforce the CC&Rs or rules if it's not in the best interest of the association. So if your board decided that a requirement in the CC&Rs about a particular material that had to be used was not in the best interest of the association, it could choose not to enforce that provision of the CC&Rs. And the statute basically says it doesn't invalidate the rest of the CC&Rs, and it gives specific criteria, one of which is it's not in the best interest of the association, for when you can basically disregard or ignore the provisions. If it was something very specific like cedar shakes, and your community had decided you're just not going to enforce cedar shakes, then I think you could even adopt a policy that says, despite the requirement in the CC&Rs that you use cedar shakes, because of the risk of fire hazard, the association is not going to enforce that provision and give it to your owners. So again, you're trying to act reasonably and prudently and in good faith and try and do what's best for your community. Anything you want to add, Diana?
Just that you should ask your association attorney if you have specific questions about a specific building component that the board may want to change. Um, I'll move on to the next question. Our HOA president resigned last week. We did not have a vice president. None of the other directors want to be president. Our annual meeting is 3 months away. Can we operate with a rotating chair? And the short answer is yes. You can technically function without a president. And that's because the board makes decisions as a whole, not just the president. But you cannot have the president and secretary be the same person. So the other board members, I'm not sure what role this person has or if they're even a board member, but the other board members can fill in the role of a president for the 3 months, but not the secretary. And board presidents typically run board meetings, but you can have any other board members chair the meeting. You could ask your manager if you have one, or an attorney, or a reasonable person to chair the meeting.
The word is parliamentarian.
Yeah, I did read that.
A parliamentarian is a person who would serve to enforce Robert's Rules of Order, and they are that there are societies of parliamentarians.
Okay, good to know.
Yeah. So,
Do you have anything you would like to add to that?
no,
Okay.
anyone can chair a meeting. The
Yes.
board just has to agree on who's going to chair it to try and avoid fights. Next question. How can an HOA board determine if any of their governing documents need revision or whether there are conflicts? So the short answer is you can have your association attorney review the documents for conflicts. You can also just read the statute online and identify conflicts for yourself. But I guess part of the answer is that we know there are conflicts in your documents. Because if your documents are more than 3 years old, even if you're already under WUCIOA, there are changes in the statutes that are going to differ from what your governing documents are. And these provisions for meetings are the best example because we talk about them a lot. Those were not in the original WUCIOA statute. So you've got conflicts. The question really is, do you care or do you need to do anything about it? So we know that all the documents are limiting executive sessions. They are requiring open meetings and 14 days notice. You're as WUCIOA goes forward, you're going to have to use secret ballots for voting. You won't be able to restrict voting by delinquent owners anymore. So there are conflicts. And so really the question is, what do you want to do about it? And I will offer that we are being hired routinely to go through and find these conflicts and make recommendations to clients about what they should do about them. And the answer is almost always, rewrite your document to comply with WUCIOA. So we're typically now just advising people, saves the money on the document review, and just if you want your documents to line up without having to cross-reference WUCIOA, then just have an attorney rewrite the documents for you. And it can be written to just make the changes required by WUCIOA and not change any of your other rights and obligations. And that's a relatively straightforward process. Or you can adopt a lot of changes which are allowed by WUCIOA, but not required. And we're seeing most communities choose to fix other problems at the same time, like eliminating the cedar shingles from the required building materials, or adding provisions about insurance and shifting the insurance deductible if it's a condominium, clarifying things that people have been arguing about for years, like who pays for the fence between two neighbors. So you can fix problems and make the documents better at the same time if you are going to modify it to comply with UCIOA. So anything you want to add, Diana?
No, I can move on to the next question, which is submitted by the same person. So if there are conflicts, is it sufficient for the association to adopt WUCIOA without updating the documents? And the short answer is probably not. RCW 6490-285, Section 10 allows associations to remove or otherwise amend as necessary the language that's currently in your governing documents that are in direct conflict with WCIOA. And part of the answer is that you should ask your association attorney whether these changes are recommended for your community. But you could amend or remove the direct conflicts with 30 days notice to the owners and with 2/3 vote of the board and without a vote of the unit owners. But again, it only works for direct conflicts. And many provisions of WCIOA allow for things, but do not create conflicts necessarily. They don't directly conflict. And just because something is allowed under WCIOA doesn't mean it, again, directly conflicts with your current governing documents. So for example, as Ken just explained, the ability to assess the association's insurance deductible to the owner for condominiums, that's something you could do under WCIOA, but might not directly conflict with your current governing documents. The ability to assess costs to owners who fail to maintain certain building components like water heaters, the ability to vote by mail, proxy, or absentee ballots, assessments for costs to maintain limited common elements, the ability to restrict the number of rentals or the length of rentals. These are all things under WCIOA that you could do. It's just, again, it might not directly conflict with what your governing documents state. And also, for example, WCIOA allows you to amend your governing documents with 67% approval. But if your declaration requires 75% approval to amend your documents, it will still be 75 because that's, even though it's allowed by WCIOA, your current governing documents say 75. And do you have anything you would like to add to that?
Well, I would just clarify on the amendment. UCIOA sets a floor of 67% for amendments. And many older condos have a current amendment threshold of 60%. And some community associations have thresholds which are as low as a majority of a quorum at a meeting. And those lower percentages will be wiped out by UCIOA. But if the percentage is higher, that's allowed by UCIOA. So if it's 75 or 80%, UCIOA says it has to be a minimum 67 and not higher than 90%. So those would still continue at the higher level. But that's all I've got. Addition.
Okay, great. I
We
think
went out of questions that were submitted in advance. If people wanted to,
there are some questions in the chat I could read off. The first question is, how do we determine whether certain costs should be covered from our maintenance fund or from the reserve?
okay, so I don't know if this is the same person who I was talking to in a board meeting last night. The statute actually defines what kinds of expenses go into a reserve study. So it's something which does not occur on an annual basis, um, meaning it's less frequent than on an annual basis. And it should relate to a building component. So cleaning your gutters is an operating expense, not out of reserves. And replacing the gutters is out of reserves. Now, if you've got something like a tree falls and damages a gutter and you repair the gutter, I'd say that's probably going to be a operating expense because it's a one-time non-recurring event. So there is some flexibility, and I've certainly seen clients be very specific when they are approving a motion to take a particular repair and specify whether it's coming from the operating budget or from their reserve budget. So, for example, if their one client replaced the mats in their elevators, and their their reasoning was that these mats were supposed to last 5 years, so it could be a reserve expenditure because they're only doing it once every 5 years. And the reserve study itself would be a pretty good guide on whether an expense should be in the reserve category rather than the operating expense category. Because if it is the performance of one of the tasks in the reserve study, I'd say it is presumed to be a reserve expense. Some things like repairing the irrigation system. If you are every spring sending a crew out to repair the irrigation system to bring it up to 100% performance, that's an operating expense because you're doing it every year. But I don't know if there's anything you want to add, Diana, or your thoughts on it.
Nope, I think you covered it. There are many other questions. The next one is there a specific procedure the homeowner must follow to challenge a decision within 90 days? If so, where do we find that?
So the statute says, or the section it's in is 4452L.
Yeah, 2L.
And it says that the decision is valid unless it's set aside by a court. And I would say that the way you would challenge it, the specific way, is going to be by filing a lawsuit. Now, that doesn't mean that if you've got a legitimate challenge and you bring it to the board's attention a month after the event occurs, that the board won't reconsider and correct whatever procedural mistakes they've made. And that's what I expect to happen most of the time, is that a challenge will come because a decision was made without giving 14 days notice, or there wasn't an owner comment period. And so if the board goes to an attorney and says, what do we do? The attorney's going to tell them, back up, follow the procedure. And if you can follow the procedure and get the vote required, then it will be a valid decision going forward. So let's say you adopted a rule against cats and you didn't follow the procedure, which under WUCIOA is that you must give an advance copy of the rule against cats to the owners to review, must give the owners an opportunity to comment about the rule on cats. Then you have to have a board meeting where you adopt the rule against cats. And then you have to distribute the rules again to the owners saying, hey, we adopted a rule against cats. So it's a procedure process. And if any of those steps were missed, an owner could come and challenge the validity of the rule against cats because you didn't follow the procedure. So what this provision says essentially is if the board doesn't fix the procedure, then the rule against cats is going to be valid 90 days after it's been distributed to the owners. And so the owners have 90 days, and you'd start by bringing it to the board's attention with a letter or come to a board meeting and talk about it during the comment period. Have your attorney write a letter. If the board doesn't agree to fix whatever the process is or change their mind, then you can file a lawsuit. Do you have any thoughts on that, Diane?
No, I think you covered that. The next question is, we discussed the Fannie and Freddie guideline letters a couple weeks ago. And I believe this person is talking about our Q&A session that we covered. We did a lesson on this a few weeks ago. They have a follow-up question on the 15% requirement. Is that 15% of the reserve account be fully funded, or 15% of the association's revenue being dedicated to funding the reserve account?
It is, I've got the letter sitting in front of me, so I will take a quick look at it to confirm. But it is 15% of the association's budget. And I think it is 15% of the budget excluding the reserve contribution. There's a lot on insurance too.
And we could also always cover
It's
this.
it's 15% of the, I'm pretty certain it's 15% of the operating budget goes to reserves.
Okay. The next question is, what statute establishes the restriction that the secretary cannot serve as interim president during a vacancy? And that's from the Washington Nonprofit Corporation Act, RCW 2403A 585, Section 3, and I'll put that in the chat.
It doesn't mean the secretary couldn't chair a meeting. It just means the secretary can't sign a document on behalf of both the president and the secretary.
Okay, and the last question is pretty lengthy and very specific. So that's too specific for this forum. If you have questions you would like to send to your association attorney, this might be a good one. I believe there are no other questions, or if we did not get to your question today, it's because it's too specific for this forum. If you have questions for next week, please submit them to info@condolaw.net by Monday end of day. And thank you for joining us today.
Thanks, everyone.
Thank you. Bye.